Imagine you're advising a client. Maybe they're looking at a really hot UK startup. Or perhaps it's your own fund considering an investment over there. How do you quickly get a handle on those crucial legal differences, especially when you're maybe more used to operating in a different legal landscape? It's a challenge, right, for lots of legal and finance professionals. And today, we're tackling it head on. We're diving deep into a specific analysis of UK early-stage equity financing, one actually prepared for a Luxembourg audience.
Exactly. Our mission in this deep dive is really to unpack this expert analysis. We want to pull out the most important nuggets of knowledge, highlight the key concepts, and crucially make those vital comparisons between the UK's common law approach and what might be more familiar in a civil law system, like Luxembourg's.
Yeah, and we've got this fascinating source document to guide us. It's quite tailored. It even sets the stage by addressing its specific audience directly. It really underlines how this analysis is, well, custom built for professionals navigating between these different legal worlds. Okay, so let's jump right into UK venture capital landscape.
Right. So the analysis, it kicks things off by setting the scene. The UK is still a major global VC player. In 2024, it was second only to the US and actually leading Europe, attracting something like 36.6% of the continent's total venture capital.
Wow, 36.6%.
Yeah, it's significant. And the key sectors highlighted are AI, fintech that accounts for about 24% of investment, in life sciences, which is around 20%.
That's a serious concentration of capital and innovation. And the analysis points to a shift in the market dynamic too, right? Less focus on just growth at all costs.
Exactly. The source material notes a very clear move towards emphasizing profitability, strong unit economics, the fundamentals. And this translates into investors being, well, more cautious with valuations and critically a much greater intensity on thorough due diligence, both commercial and legal, before they put capital to work.
Okay, makes sense. So with that context, what's the foundational legal backbone for these UK companies?
The analysis identifies the Companies Act 2006. That's the core statute. It governs pretty much everything, from incorporating a company right through to how it handles financing rounds. But here's a fundamental point, especially emphasized for that Luxembourg audience. The UK is a common law jurisdiction.
Ah, yes. The core common law versus civil law distinction. How does the source explain how that actually impacts practical things, like interpreting laws or, say, contracts?
Well, it notes that common law relies really heavily on judicial precedent, case law alongside the statutes. That's quite different from civil law systems where the written statutes are usually the primary source. For contracts specifically, UK common law tends towards a much more literal interpretation of the written terms.
Okay, literal interpretation.
Yeah, and the concept of good faith is, while less pervasive or automatically implied in UK contract law compared to many civil law jurisdictions, and things like pre-contractual discussions. They generally have evident impact unless they're expressly baked into that final written agreement.
Got it. So what's the standard company structure that VC investors typically encounter in the UK then?
The analysis focuses pretty squarely on the private limited company, the LTD, its key features. Limited liability for shareholders, capped at whatever they haven't paid on their shares, separate legal personality, of course, and importantly, restrictions on offering shares to the public.
And that's a key contrast, isn't it? Especially thinking about, say, a Luxembourg SA.
Absolutely. The source explicitly draws that contrast. It notes that even a closely held Luxembourg SA is still formally a public company, and it comes with more extensive statutory requirements. The LTD structure is generally seen as simpler, maybe more flexible, particularly for those early-stage companies.
Okay. What's another critical, practical difference the analysis highlights, especially for professionals coming from a civil law background thinking about corporate transactions?
The role of notaries. Yes, the source puts significant emphasis on this divergence. In Luxembourg, as you know, notaries are often central, frequently mandatory for many corporate actions and corporations, share issues, amending articles. Formal deeds are standard practice.
Right. And the UK approach, how does that differ?
Well, the analysis points out that the role of a UK notary public in domestic company law transactions is far, far more limited. Most key actions for private companies like issuing shares, amending their articles, they just don't require notarial intervention. This fundamentally impacts the formality, the timeline, and of course the cost of transactions compared to many civil law processes. It's a really vital contrast to grasp. The analysis then kind of walks us through the typical VC investment lifecycle, which, happens in stages or rounds.
Starting with the very earliest phase.
That would be pre-seed or seed funding. This is really for building an MVP, doing market research, getting some initial traction. In the UK, the amounts might be, say, 100 pay up to maybe 2 midders, often funded by angels, friends, family, maybe accelerators.
Okay. And then comes the first significant institutional round.
Series A. Yeah, this round is much more about validating and starting to scale the business model. Funding amounts in the UK typically range from about £2 meters to 15 meters, and it's primarily driven by VC firms at the stage. Then you had subsequent rounds, Series B, C, and so on. They're for further scaling, often with a much greater focus on profitability. You're looking at larger sums, potentially involving growth equity or even private equity investors. It's a clear progression, really tied to hitting milestones and de-risking the investment.
Makes sense. So who are the core parties involved in these typical UK VC deals?
Well, obviously, you've got the company itself. The founders, absolutely key. The investors that could be angels, VC firms, or increasingly corporate VCs, strategic investors, and then the essential advisors, legal, financial, sometimes technical or commercial experts, too. The source even notes something interesting, how the BVCA model documents, the standard ones, have optional wording. Yeah, to actually restrict information access specifically for strategic investors within the shareholders' agreement, which kind of highlights how deal terms adapt based on who the investor is.
Interesting detail. Okay, let's move to the start of the formal deal process then, the term sheet. The analysis breaks this down using the 5 W's and H framework. Who usually prepares it?
Typically, it's the lead investor or their legal counsel who drafts it up, and it's presented to the company.
And why do they do this? What's the purpose?
Really, it's to outline the essential commercial and legal terms right up front. It acts as a kind of roadmap for the much more detailed, definitive documents later on. And importantly, it helps surface any potential deal-breaking issues early, before everyone racks up significant legal costs.
Makes sense. When does this usually happen in the timeline?
Typically after the initial commercial discussions have taken place, maybe some high-level due diligence, but definitely before the full deep dive due diligence and before the lawyers start grafting those lengthy definitive agreements.
Okay. And what exactly is a term sheet? Physically.
It's basically a summary document. It can range from just bullet points to a more structured letter format. It details the proposed terms of the investment. Actually, the BVCA now even includes a specific summary of terms document in its model suite.
And where do the negotiations happen?
Primarily between the principals, so the key people on the company side and the investor side. Their legal counsel will be advising them, of course, on the implications of the terms being discussed.
Right. And how does that negotiation process work?
It tends to be iterative,
Yeah.
Proposal, review, negotiation, amendment, back and forth until hopefully agreement is reached on those key points. Now, here's a critical point: the legal status of a UK term sheet. The analysis points out that most of the commercial terms are typically not legally binding. They're usually expressed as being subject to contract.
Ah, okay. But some clauses usually are binding right from the get-go.
Yes, exactly. This is a key distinction. The source highlights things like confidentiality, exclusivity, that's the no-shop clause preventing the company talking to other investors, governing law and jurisdiction, and sometimes provisions about costs like break fees if the deal falls through. Those specific clauses are usually intended to be legally binding immediately. The non-binding commercial terms, though, while you can't sue on them, they're generally treated as binding in honor. There's a strong expectation they'll form the basis of the final deal.
Binding in honor. Okay, so what are some of the most heavily negotiated terms you typically see in a term sheet, according to this analysis?
Well, valuation is always front and center. Pre-money, post-money valuation, and critically, how it's calculated, usually on a fully diluted basis, the investment amount itself, obviously. And the type of shares being issued, usually a new class of preference shares for VC rounds. And then associated with those preference shares are all the critical rights, things like liquidation preference.
And the analysis mentioned 1x non-participating is common in the UK.
Yeah. The source notes that 1x non-participating is often seen as the market standard starting point in the UK. Also, dividend rights, conversion rights, how the preference shares convert into ordinary shares, and anti-dilution protection.
Right, anti-dilution. The analysis mentioned broad-based weighted average.
It does. The source explains the basic principle. If the company later raises money at a lower price per share, a down round, the investor's conversion price gets adjusted downwards. This means they get more ordinary shares when they convert, protecting their percentage ownership to some extent. The weighted average part makes it less harsh than a full ratchet mechanism, which you don't see very often in the UK market. Other heavily negotiated points are investor rights, things like board representation, getting a seat on the board, information rights, access to company information, and crucially, consent rights or vetoes over significant company actions. The source lists typical examples of these reserved powers.
What kind of thing?
Things like issuing new shares, changing the company's articles of association, taking on significant debt, selling off major assets, changing the core business, appointing or removing the CEO, approving annual budgets, that kind of thing.
That reserve matters list, that's really where investors exert significant control or influence, isn't it? What about conditions precedent, the things that need to happen before the deal actually closes?
Right, CPs. Common ones listed include satisfactory completion of all the due diligence, obtaining CEAS or EIS advance assurance from HMRC if those UK tax reliefs are relevant, getting key documents signed like founder service agreements and crucial IP assignment agreements, key person insurance being put in place, confirmation that there's been no material adverse change, no MAC, a warranty bring down, meaning the warranties are confirmed as true again right at closing, getting the necessary shareholder approvals like the vote to adopt the new articles, and any required regulatory approvals, maybe under the National Security and Investment Act, the NSIA. The source also flags that legal nuance in English law around the endeavors, standard reasonable endeavors versus best endeavors for actually fulfilling those CPs, different levels of obligation.
Interesting. And the term sheet also sort of sets the stage for warranties, doesn't it? Even if the detail comes later.
Yes, exactly. It'll typically state that warranties will be given by the company, and sometimes the founders, too. These are basically contractual statements of fact about the company, its business, its assets, liabilities, and so on. If a warranty turns out to be untrue, the typical remedy is a claim for damages compensation for the diminution in the value of the investor's shares. The source highlights this as a common law concept, quite distinct from, say, civil law guarantees against hidden defects, which might offer different remedies like rescission. Warranties themselves are subject to heavy negotiation, their scope, any qualifiers like materiality or so far as the company is aware, and limitations on the company's liability. Think financial caps, time limits for claims, minimum claim thresholds like de minimis or baskets, and crucially, they interact directly with the disclosure letter.
So it sounds like negotiating that term sheet is absolutely vital, even if large parts of it aren't technically legally binding at that stage.
Absolutely vital, yes. The source really emphasizes that it lays the groundwork, sets the framework for the entire transaction. Pitfalls include things like vague wording, being unclear about which parts are binding, or accidentally creating commitments you didn't intend to. Okay, so once the term sheet is agreed, the process moves into due diligence, or DD. This is carried out by the investor and their team of advisors, legal, financial, technical, commercial, etc.
And the purpose of this stage, why is it so important?
Well, fundamentally, it's to verify the information the company has provided, to gain a really deep understanding of the business operations, the market, the risks, the opportunities, and of course, to identify and assess any potential risks or hidden liabilities. The findings from DD directly influence the final decision to invest. They shape the warranties that get negotiated into the final documents, and they confirm if the conditions precedent can be met.
Right. And what's a typical scope of the legal due diligence in a UK VC deal?
The analysis details the key areas: reviewing the corporate structure, making sure it's compliant with the Companies Act, checking the statutory registers, looking closely at the share capital history, the cap table, scrutinizing intellectual property ownership, assignments, especially from founders and key employees. This is often absolutely critical for early-stage tech companies. Reviewing material contracts, particularly for things like change of control clauses, employment matters, data protection compliance under UK GDPR, any litigation, current or potential, and regulatory compliance, including things like the NSIA screening. While it might be, slightly lighter touch than a full-blown M&A due diligence process, the source notes the focus is intense on the areas critical to early-stage value, particularly that IP and the strength of the founding team. And this leads us directly to another key UK legal document, the disclosure letter.
Okay, the disclosure letter. What exactly is its role in this process?
So the disclosure letter is prepared by the company and its lawyers, and it's delivered to the investors usually just before signing the final agreements. Its purpose is to qualify the warranties that are being given in the subscription agreement. Essentially, anything that is fairly disclosed in this letter prevents the investor from later bringing a warranty claim about that specific matter. It's a formal risk allocation tool. The investor is basically put on notice and deemed to accept the risks that have been properly disclosed.
Okay. Fairly disclosed. What does that actually mean in practice? What makes a disclosure count as fairly disclosed?
That's a key point. The source emphasizes the UK legal standard here. It generally requires the disclosure to be clear, precise, and sufficiently comprehensive, so that a reasonable investor can properly understand the nature and scope of the issue being disclosed and its potential implications without having to hunt for it. Simply dumping vast amounts of information into a data room and saying it's in there somewhere is often not enough to meet the fair disclosure standard, unless the subscription agreement specifically says that anything in the data room counts as disclosed, which investors usually resist. This specificity is a critical aspect of UK practice.
Got it. And the data room itself.
The virtual data room, the VDR, is the central online repository where the company uploads all the documents for the investors and their advisors to review during DD. A well-organized data room is crucial, just for efficiency and making a good impression. While its contents obviously inform what goes into the disclosure letter for the company to be safe, making a direct and specific reference to the relevant issue in the disclosure letter itself is the standard way to ensure a matter is considered fairly disclosed against the warranties. Okay, so moving on, let's look at the core legal documents that get signed at closing. The analysis highlights the British Venture Capital Association, the BVCA, model documents. Their subscription agreement, shareholders agreement, SHA, and articles of association, AOA, are widely used as benchmarks, as starting points, in the UK for Series A rounds and later. It's worth noting, though, these aren't typically used for the very early seed rounds, which often use simpler documents like advanced subscription agreements or seed fasts.
Okay, so focusing on that Series A package. First up, the subscription agreement.
Right. This is the main binding contract under which the investors agree to subscribe for the shares, and the company agrees to allot those shares to them. It's all subject to the conditions precedent we talked about being satisfied or waived. The parties are usually the company, the investors, and often the founders are parties too, particularly as they might be giving some warranties alongside the company. It contains the full, detailed list of warranties covering everything from corporate status, accounts, IP, data protection, employment, etc. The source notes recent BVCA updates have added warranties on things like AI use, insolvency risk, anti-bribery, anti-money laundering, and sanctions compliance. And it also contains the formal final list of conditions precedent to closing.
Okay, then there's the shareholders agreement, the SHA.
Yes, the SHA. This is a private contract. It sits alongside the public articles. It's between the shareholders, so founders, investors, maybe others, and usually the company is a party too. It governs their relationship after the investment closes and dictates how the company will be run. It details all those investor protections we mentioned from the term sheet, like the specific consent rights or vetoes that detailed reserved matters list again, information rights, access to reports, accounts, etc., and that potential carve-out for strategic investors is often documented here. And board representation rights, maybe with details like observer rights or indemnity provisions for the investor directors.
And what else is typically found in the SHA?
Share transfer provisions are absolutely critical, things like rights of preemption or ROFR, right of first refusal if shareholders want to sell. And the really important drag-along and tag-along rights, which govern how everyone sells together in an exit scenario. It also usually includes founder and management provisions. This is where you find the detailed definitions of good leaver versus bad leaver scenarios if a founder departs, and what happens to their shares. The source notes a recent BVCA update changed the default treatment for simple resignation, making it less automatically punitive. More interested covenants on founders' non-compete, non-solicit are also in here. You'll also find company undertakings positive promises, things the company will do, and negative ones, things it won't do without investor consent. Again, BVCA updates noted on things like enhanced compliance and governance procedures. It usually requires new shareholders who join later to sign a deed of adherence, basically agreeing to be bound by the SHA's terms. And a crucial point, while the SHA itself is a private document between the parties, many of the key rights defined in it, especially those affecting share rights, governance, and share transfers, must also be embedded or reflected in the company's public constitutional document, the Articles of Association, to be fully effective and binding on the company itself and all shareholders present and future.
Right. Which brings us neatly to the Articles of Association, the AOA.
Exactly. This is the company's public rulebook, its constitution. It's filed publicly at Companies House. A new set of articles is formally adopted by the shareholders at closing, replacing the old ones, to reflect the terms of the new investment round. They define the different classes of shares: ordinary, preference shares, and set out their specific rights. So this is where the technical details of things like the liquidation preference waterfall are formally laid out: how proceeds are distributed on a sale or winding up, whether the preference shares participate further after getting their money back. The source notes BVCA updates here on calculation mechanics, currency issues, and accommodating specific EIS-VCT tax relief preferences. And the anti-dilution protection mechanics, that specific broad-based weighted average formula and how it's calculated, are formally enshrined in the articles.
Okay. Were there any recent legal developments or sort of wrinkles that impacted the articles mentioned in the analysis?
Yes, actually. The source specifically mentions a court case called Dina Nudge. It raised some uncertainty. The question was whether simply exercising a pre-agreed right that was already written into the articles, like converting preference shares into ordinary shares, might unintentionally be considered a variation of class rights under the Companies Act, which could trigger the need for a separate vote or consent from that specific class of shareholders.
Okay. That sounds like it could cause procedural headaches.
Yeah.
So how did the market or the BVCA documents address that potential issue? This seems like where precise drafting becomes absolutely critical.
It does, and the source highlights that the BVCA model articles and SHAs were subsequently updated to add specific wording. The clarification essentially states that exercising these predefined rights, like conversion or reclassification of shares on certain events, provided it's done strictly in accordance with the terms already set out in the documents, will not be considered a variation of class rights requiring a separate formal class consent process under the Act. It's a really good example of how English law drafting evolves based on case law to provide certainty and ensure the agreed commercial mechanics actually work as intended without procedural blocks. The articles also cover the general procedures for formally varying class rights when needed. Usually requires a 75% consent from the holders of that class. They contain rules on share transfers that mirror or implement the SHA provisions, rules on dividends, company meetings, director appointments. And the source mentions recent BVCA additions, like specific sanctions provisions, designed to help companies avoid issues if they end up with sanctioned persons as shareholders.
Okay, so we've got the terms agreed, due diligence completed, the complex documents drafted and negotiated. What are the actual legal mechanics involved in issuing the new shares in the UK?
Right, the execution phase. It's governed primarily by the Companies Act 2006 and the company's own articles. First key step. The directors need the proper authority to allot the new shares. That's under Section 549 of the Companies Act. Usually this authority is granted by the shareholders passing an ordinary resolution needing a simple majority, 50% plus of votes cast. Then, a really crucial step, particularly in VC rounds, is disapplying the statutory preemption rights. These are found in Section 561 of the Companies Act.
And why is that necessary? What do those rights do?
Well, the default statutory position is that when a company issues new shares for cash, it generally has to offer them to its existing shareholders first, in proportion to their current holdings. To allow the company to issue the shares directly to the new investors in the funding round, as intended, these preemption rights usually need to be formally disapplied. The source notes this typically requires a special resolution passed by the shareholders needing a 75% majority vote under Sections 570 or 571 of the Act. Or, alternatively, the preemption rights can sometimes be excluded entirely in the company's articles, though disapplying them round by round via special resolution is very common. Adopting the new Articles of Association also requires a special resolution under Section 21, needing that 75% majority. And those new articles must be filed with Companies House within 15 days of being adopted.
Okay, and what other key Companies House filings are needed after the deal closes?
The source lists several critical ones. There's Form SH01, the return of allotment of shares. This has to be filed within 1 month of the shares being allotted, and it includes the crucial statement of capital, which shows the company's share capital structure after the new shares have been issued. The new articles, as we said, within 15 days. Updates to the company's register of persons with significant control, PSC, need to be filed within 14 days of the company updating its internal PSC register, using forms like PSC over 1. And any changes to directors, like appointing the investor's representative to the board, need filing using Form APO1 within 14 days. Similarly, if a company secretary changes, that needs filing too. Keeping companies' house updated is vital. And here's another point of particular interest for a Luxembourg audience, highlighted in the analysis: stamp duty. The source points out that in the UK, there's generally no stamp duty payable on the new issuance of shares by a company directly to an investor. Stamp duty typically applies only to transfers of existing shares between shareholders, and even then, only if the value is over £1,000.
Ah, that's definitely a notable difference compared to some other jurisdictions. What about keeping the company's own internal records up to date?
Absolutely vital. The Companies Act 2006 mandates that companies maintain various statutory registers. And the key one here is the Register of Members required under Section 113. The analysis stresses this. The Register of Members is the definitive legal evidence of who owns the shares in a UK company. It's not the records held at Companies House, nor is it the share certificate itself. Legal title rests on what's recorded in the company's own Register of Members, so keeping that accurate is paramount. The registers of directors, directors' residential addresses, secretaries, and the PSC register also need to be diligently maintained internally.
And share certificates, do they still matter?
They do. The source confirms the company must issue share certificates within 2 months of the shares being allotted under Section 769 of the Act. They serve as important documentary evidence of ownership for the shareholder, but, as we just said, the ultimate legal proof of title is the entry in the Register of Members. Finally, let's just touch on timelines and costs, as the analysis does. Timelines for, say, a UK Series A round, from agreeing the term sheet through to closing, can vary quite widely, naturally, but the source estimates a typical range might be somewhere between 2 and 20 weeks for that phase. The entire fundraising process, from the company first starting to look for funds, can often take 3 to 6 months or even longer. The due diligence phase and the negotiation of the definitive legal documents are usually the parts that take the most time.
Makes sense. And the financial side? Raising money isn't free, of course.
No, indeed. Legal fees are obviously a significant cost for the company itself. The source suggests a very wide range, maybe 10K to 100K or even more, depending on complexity. But critically, the source states it's standard market practice in UK VC deals for the company to pay the investors reasonable legal fees as well. This is usually subject to a pre-agreed cap, which is often specified right back in the term sheet. Other DD costs, like fees for financial or technical advisors hired by the investor, are typically borne by the investor, although that can sometimes be negotiated. And things like arrangement fees or ongoing monitoring fees might also apply, depending on the VC fund.
Okay, so pulling this all together then, thinking specifically from that Luxembourg perspective that the analysis was prepared for, what are the key comparative takeaways?
The source does a good job consolidating these points. First, that fundamental difference in approach. Common law versus civil law. Especially regarding contracts, the emphasis on literal interpretation in the UK versus potentially broader concepts of good faith, and how pre-contractual statements are treated differently. Then, the nature of warranties in the UK system, primarily leading to a claim for damages based on loss of value versus how civil law guarantees might operate, potentially offering wider remedies like rescission or specific performance. Disclosure practices, too. That formal disclosure letter process and the specific UK standard of fair disclosure is presented as being perhaps more structured and specific than potentially relying solely on general duties of good faith disclosure that might exist in some civil law systems.
Right, and the procedural distinctions.
Those seem quite stark in the comparison. The massive difference in the role of notaries, their central, often mandatory role in Luxembourg corporate acts, versus their very limited role in UK domestic company law for these types of transactions. The explicit UK procedural step of having to formally disapply statutory preemption rights via shareholder resolution. The difference in the public versus private nature of the key governing documents, the articles being public at Companies House, while the SHA remains a private contract. That critical difference in the proof of title, the absolute primacy of the UK company's own Register of Members as the definitive legal evidence of share ownership. And, as mentioned, the practical point of having no stamp duty on the issuance of new shares in the UK. Also, understanding how those contractual rules agreed privately in the SHA need to interact with and often be embedded within the constitutional rules in the public articles, a dynamic highlighted by that Dino Nudge case, is presented as a specific nuance of the UK's dual document system, perhaps compared to systems where rights might be more solely embedded within the company's articles or statutes in a civil law context.
So this deep dive, really tailored for professionals who might be bridging that gap between civil law systems like Luxembourg and the UK's common law approach. It really zeroes in on those critical areas where assumptions could be wrong or misunderstandings could easily arise, couldn't it?
It absolutely does. It underscores the need for really meticulous attention to detail when dealing with UK common law documentation, the importance of following those specific procedural steps in statutory filings very precisely, and the real-world impact of core concepts like fair disclosure for managing risk, and the absolute primacy of that register of members for establishing legal title to shares.
Yeah, navigating cross-border investment really demands appreciating these, sometimes subtle, sometimes quite stark differences. Thinking about all these contrasts we've discussed, from the nuances of contract law and the role of notaries, to the specifics of warranties, disclosure, public versus private documents, and even how you prove share ownership. What does this comparison ultimately reveal about how these different legal traditions, common law and civil law, approach that fundamental balance? The balance between protecting investors, providing flexibility for the company to grow, and ensuring a degree of public transparency in the whole early-stage funding process.